A matter of First American Title Insurance Company versus Euless Wilson, 45 CO1, 1309 PL 95. Ms. Bowles, on behalf of Mr. Wilson and counsel, you are?
Justin Smith on behalf of First American Title.
All right. And we're here for today on...
I'm motion to set aside the default.
Okay. We will proceed.
Your Honor, in looking into the background, because I just came into the case and and then it got continued over because I just started.
Right.
And looking into this case, certainly in order to set aside the default, we've got to have an underlying basis,
Meritorious defense.
Yes.
Okay.
And so, Mr. Dustin's client, I'm sorry, has a signed note by my client. But I guess our problem is that my client never owned the property. He's never been in the chain of title. When we looked at this thing, this all happened it started in 2008. In talking with the people, in the next building, and on February 6th of 2008, Caruso deeds the property to Garcia.
Caruso's involved in this?
Yes.
Okay. Go on.
But again, like I say, my client is nowhere near this. He signed the note, which is what they're suing on their note.
Okay, did he get the money?
Well, the money went to Wells Fargo, I believe, right? To satisfy that mortgage, or how does that go?
He borrowed money to buy property, so that's all we know is that he signed a note to borrow money from the bank.
Borrow money to buy property.
Yeah.
It never.
And he never bought the property?
Right, he never got a deed in his name. Never. So the question is, where did that money go?
How could that have happened? Wasn't there a title policy? Wasn't there a title? Before a bank lends money, usually there's a title, isn't there?
Well, that's why some title companies here suing on this notice is the title company had to pay out under the policy. I mean, we got the note from the mortgage was assigned to us from the bank after we paid off our insurance, which was the bank.
Okay. How is the title company paid off the loan? Why?
No, Mr. Wilson took out a loan and signed a mortgage to buy property.
Okay.
During that transaction, the bank retained First American Title Company to do a search and to ensure the closing.
Okay.
And then through whatever happened, chain of events happened after that, it came to the bank, or the bank became aware that they weren't either a first mortgage lien or they didn't have, the property got transferred outside of their mortgage or outside of their interest. And so they made a claim against the title insurance company, being First American. First American settled with the bank under the policy in exchange for the note and the mortgage being assigned to us. So now we are suing on the note to recover what we paid to the bank. Why Mr. Wilson never got the property is outside of this transaction.
Why would the title company go through with a deal like that? I mean, were they defrauded or what?
I assume that either they missed something on the title search or there was documents that weren't recorded in the chain. I wasn't a part of the underlying settlement negotiations with the bank. But if Mr. Wilson was defrauded, then he's got a claim against somebody else, not the title insurance company, because he wasn't our client. We don't have a relationship with Mr. Wilson.
Well, who's the title company insuring, Mr. Wilson or the bank?
We insure the bank, which is why we're here in the bank's position enforcing the note.
How much was it for?
$68,400.
And he never got any of the money.
No.
The bank got the whole 68,000, or how much the title company?
Whoever was selling the properties who got the money. The bank wasn't selling the property. The bank provided the money. So the bank gave him $68,000 so he could buy property, and they'd have.
Right, I understand that, but I don't understand how the title, what could the title company missed here? Somebody didn't convey the property to him.
What I understand
Or
is
maybe somebody didn't own the property who's selling it.
Sergio Garcia, doing business as Garuso Construction Company, owned the property, and that's who was selling the property, Mr. Wilson. And I believe what happened is he sold the property to somebody else and sold it to Mr. Wilson.
Where's Sergio Garcia, and he's been brought into this?
He probably needs to be. In fact, I know he needs to be. But also, in what
Should the bank have sued him too? Or, I mean, the title
There
company?
are lawsuits against Sergio Garcia going on, or have gone on.
Has the title company sued him also?
I think the bank has. And perhaps the title company as well. I don't have that information in front of me now.
Why didn't they sue him in this, or join him in this clause here?
Because this clause is specifically on the note.
But Sergio sold him the property and sold it to another person.
Well, if Mr. Wilson paid money to Sergio Garcia and did not receive a property in return, then Mr. Wilson has an action.
Well, right,
against-
somebody should have brought this Garcia fellow in this case, or Caruso. I mean, did he execute a deed to Mr. Wilson?
I guess my question from Mr. Wilson, is this all like news to you, Mr. Wilson?
Yeah.
But you executed a note on a mortgage and then you never moved into the property?
Right. I had intended on it being rental property.
And so when you never received that rental property, you didn't do anything about it?
I don't know what kind of,
It's not I guess it's not our burden to make sure that you
Yeah,
receive
yeah.
the rights.
I mean, did he bought this property and you never got it?
Because you tell me that Caruso was supposed to be rented.
yeah, it's supposed to get a rent and supposed to be up to my retirement age, supposed to rent until it's paid for, and then I'd be like, necessary to do my retirement. And then it's on my retirement.
What kind of property was it?
Single family.
Did you ask him about whether or not he had rented the property?
Said he had, and then he said he wouldn't pay the rent, whatever, I don't know what happened. So he just, since he didn't rent it, he couldn't let the rent pay the mortgage. That's what we're saying. It's been vacant for years.
Your Honor, we've been here since, this case has been open since last June. He's been aware of this action since last June, he sat on his hands. That's why I have a default judgment in my favor, and that's why we're here today. He waited 30 days, he filed his motion to set aside this default, and then waited until the day before the hearing to ask for a continuance. And he waited until the day of the additional time that you gave him. He waited until the day of the hearing for an attorney to show up, and then.
Ms. Bowen?
Again, I appreciate Mr. Smith's position. I do. And what I said to him, because I talked to him about this, is that I have to look at the bigger picture for my client. And so what happens here happens here. But we really need to get to the bottom of this for his sake, because because he's obviously a victim.
Well, he's on the hook for $68,000
He signed
because somebody defrauded him, obviously.
Perhaps.
Well, I mean, if the title company didn't pick it up, I don't know how this happened. How this could happen without the title
He had a
company.
relationship with Mr. Caruso, I mean,
Well, yeah, but the title, that's what you hire a title company for.
but not to represent him.
No, but you hire a title company to give you clean title before any money's dispersed, don't we? Is that what I mean, that's what a title company's supposed to do, is protecting him and the bank.
Well, we protected the bank, I mean, he's...
Well, you protected the bank because you paid him off.
Yeah.
And you left him, instead of, they should have never dispersed the money without knowing they had a clean title. I don't know, the title company seems to be walking away here, trying to stick him. He's supposed to be getting his clean title through the title company. The title company drops the ball. I'd say he's got a suit against the title company too.
And he could have exercised that right by answering the
Well-
complaint when he was aware of it. We have procedures in place for a reason, Your Honor,
Well, yeah, we do.
and he's had a year to file an answer, and he hasn't.
But it sounds to me like he has a meritorious defense. I mean, if I'm wrong, tell me.
What's the meritorious defense on the note? There isn't a meritorious defense on the
No,
note.
there isn't a meritorious defense on the note, but the title company's got some duty here.
That may be a counterclaim, but that's not a meritorious defense to our action, which is a separate issue from what we're here for today.
But did he sign a note with you or with the bank?
He signed a note with the bank.
And you're subrogating, what are you doing?
The note was assigned to us.
What do you want to do, Ms. Baldwin?
Well, Your Honor, I certainly want to make sure that my client's rights are protected. And if that means that we need to have an opportunity to assert a counterclaim, then that's what we'd like to do. Like an opportunity to be able to do that.
What about the motion for default?
Well, certainly we'd like that. Well, our initial motion, request was to have that default set aside.
But you have to have a meritorious defense to set aside that. There's no defense. He doesn't have a defense to the note.
Maybe if the bank was here, he wouldn't have a defense. But you're the title company, and they just assigned it to you.
But he admits that he signed it. He admits that he...
He admits that he signed it, but you're the title company. I mean, the title company seems to be trying to get around their duty by getting a note assigned to them.
Our duty wasn't to Mr. Wilson. Our duty was to the bank.
Your duty was to provide a clear title. It's at least my understanding of why title companies are used. To protect the bank and the purchaser. All right. I'm going to set aside the default for now. You got 30 days to file your counterclaim and bring that other party in here, and then we'll set it for a status in 60 days.
Do you want that September 5th date, Judge?
September 5th, what time?
Whatever is convenient for counsel who's traveling from Indianapolis.
Morning or afternoon, council?
That doesn't matter. The morning's fine.
Okay, 10 o'clock?
That's fine.
Judge, I think you have a trial manager to attend.
Make it 11? 11 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
All rise.